Welcome to ACS's annual Supreme Court preview. I'm Zanelle October, interim president of the American Constitution Society. If you're not familiar with ACS, and I do hope that's not many of you, we're a diverse, nationwide network of lawyers, law students, judges, scholars, and many others who are committed to upholding the United States Constitution in the 21st century by working to ensure that law is a force for improving people's lives. If you're not already a member, join us at acslaw.org. We need you now more than ever. And now I'll turn it over to my amazing colleague, Kara Stein, our Vice President of Policy and Program, who is the mastermind behind this annual event. Thank you, Kara.
Thank you, Zanelle. Thank you, Zanelle. And I want to thank Sarah Eval, and all the other staff at ACS who have made this event possible. I'm probably dating myself, but there was a commercial when I was growing up that was about how many licks does it take to get to the center of a Tootsie Pop. Some of you may remember it. And the kid goes up to all the animals, and the wise old owl says, well, let me test the theory. And he licks 1, 2, and on 3, he bites the lollipop, and he says, it's clearly 3. Well, we at ACS have been asking for the last couple of weeks, how many Solicitor Generals does it take to get ready for the Supreme Court term? And the answer is clearly 1, 2, and 3. We couldn't be more pleased to have this illustrious panel with us here today, SGs and professors alike, to talk about what we might expect from the coming term. There are already some high-stakes cases on the docket, like the challenge to the termination of DACA, and there are likely to be more added, including, just perhaps, some questions about executive power and privilege. And this is the second term that we've had Justice Kavanaugh with us. Some have opined that the court was very cautious this past term after his controversial confirmation, but I want to encourage you for an in-depth look at what happened last term. We have a new Supreme Court reviewed journal at ACS, and there's information on the registration table about how you can access it. But turning to today's panel and the coming term, I want to introduce our wonderful moderator, no stranger to ACS, Kimberly Atkins. And if she looks familiar to you, it's because she's on TV quite a bit lately. Kim is the senior Washington correspondent for WBUR and an MSNBC contributor. And in her previous gigs as Washington bureau chief of the Boston Herald and the Dolan Company newspapers, she covered the U.S. Supreme Court and national political news. And before launching her journalism career, Kim was a litigator in Boston, which makes her the ideal moderator for our conversation today. Please join me in welcoming Kim Atkins.
Hello, everyone, and thanks for joining us for our annual Supreme Court preview. There's a lot on the docket, and we have a very esteemed panel who I'm going to introduce very briefly and then get right into the discussion because there's a lot to discuss. Their full bios are in your materials. If I read them all, we would be here till tomorrow because they are just that esteemed. So I'm just going to hit the highlights. First, we are joined by Paul Clement, who's a partner at Kirkland and Ellis, and he was the 43rd Solicitor General of the United States from 2005 to 2008, and he's argued over 95 cases before the U.S. Supreme Court, including some you may know about, like Hobby Lobby v. Burwell and Rucho v. Common Cause. Clement's practice focuses on, of course, appellate matters before the Supreme Court and federal appellate courts, and he's also a lecturer in law at Georgetown University Law Center. We are also joined by Katie Eyer, who is a professor of law at Rutgers Law School, where she focuses on anti-discrimination law, and she's a leading expert on LGBTQ employment rights and social movements' use of rational basis review to generate constitutional change. Before that, she was a litigator and secured precedents in the Third Circuit, expanding the legal rights of LGBTQ and disabled employees. We are also joined by Don Verrilli, SG number 2, maybe we say. He is a partner at Munger, Tolles, and Olson, and he handles matters before the U.S. Supreme Court and courts of appeal. He served as Solicitor General from 2011 to 2016, and some of his victories include advocating in defense of the Affordable Care Act, one of the things we're going to talk about today, and marriage equality. And before he was SG, he was a Deputy White House Counsel and Associate Deputy Attorney General. We're also joined by Shoba Sivaprasad Wadhia. She is a faculty scholar and professor at Penn State Law, where she teaches immigration and asylum and refugee law and directs the Center for Immigrants' Rights Clinic at Penn State Law. Her research focuses on the role of prosecutorial discretion in immigration law and the intersection of race, national security, and immigration. And she also serves as an expert witness, lead author, and co-counsel in connection with the Deferred Action for Childhood Arrivals, which we also will be talking about today. And last but not least, SG number 3, Walter Dellinger. He served as acting Solicitor General from 1996 to 1997, during which he argued 9 cases before the court during that time, the most by any Solicitor General in over 20 years. He's testified more than 25 times before congressional committees and has argued a variety of notable cases before the U.S. Supreme Court and courts of appeal. Thank you all for joining us, and I want to get right into the discussion. And I'd like to start with Paul to give us a sense of the fact that the Affordable Care Act is back before the Supreme Court this term with some cases that the court has taken up about the risk corridor and the so-called bait and switch, which some of the claimants say the program was. Give us an overview about those cases.
Sure. Well, thank you. It's great to be here. I'll give you a quick overview. I'll start with the disclaimer that I'm one of those lawyers for the claimants that may have said something about a $12 billion bait and switch. So I'd take this all with a grain of salt. But I think I can give you a fair description of this case from the Affordable Care Act. It's not sort of the Affordable Care Act case that you may really want to hear about, which is the one that's working its way up through the Fifth Circuit and may or may not ultimately get to the Supreme Court, say, next term, which is a case that potentially could sort of through severability analysis potentially endanger the whole act. This is a more kind of traditional case in the sense that it deals with one particular provision of a law that has a lot of different particular provisions, and it particularly deals with the fiscal consequences of this particular provision, which I'll describe in a second. The only other thing I'll say by way of introduction is, everything about the Affordable Care Act was kind of outsized and big. It was a big piece of legislation. It had huge consequences for the healthcare industry. So maybe it's not a surprise that when you have an issue about how to make payments under this hugely important statute, that the amounts in controversy are very large. And this is literally a case about whether or not the government has to write essentially a $12 billion check to insurers based on promises Congress made back in the Affordable Care Act. So just to set the stage briefly, there were provisions in the Affordable Care Act, affectionately known as the Risk Corridors Program. These provisions were in the statute to deal with a very particular problem, which is when the new exchanges were set up. The whole point of the new exchanges was to provide health insurance to individuals who previously were not in the healthcare market. And precisely because they weren't in the healthcare market previously in a traditional sense, estimating the risks of covering them, how costly it would be to provide health insurance for them was very difficult for the insurance industry, and the government knew that. So what they tried to do is to set up a system where they would essentially eliminate some of the risk for the health insurance industry in providing this coverage. And the idea was that by sort of cushioning the risk, they would get more health insurance companies to provide policies on the exchanges, get more competition, get lower premiums. That would have a whole host of advantages, probably not the least of which is it would reduce the amount of outlays the federal government had to make for tax subsidies to cover the payments. So the statute provided essentially a system where if an insurance company incurred more losses than it might have expected, the federal government would cover some percentage of those. And there was also a parallel provision that said that if actually an insurance company sort of, priced the policies a little too high and made more money than expected, they would contribute some money into the federal government. Well, as the policies actually played out, and in light of some various sort of policy decisions that were made, it turned out that the vast, vast majority of the insurance providers had greater costs than they expected, very few payments into the program, and very many payments out that were expected by the insurance company. Of course, he had some changes in the composition of the House of Representatives between the initial passage of the ACA. So when it came time to actually make the payments that were due under the Risk Corridor program, sort of a funny thing happened, which is Congress decided it wasn't going to appropriate any money to make the payments. They did it with some appropriations riders. The text of the riders simply says that the money in that particular appropriations bill can't be used for payments under the program. So the appropriations riders don't purport to say that no payments will be made. The statute doesn't, the appropriations riders don't purport to say that the obligation is wiped out. They just say that the payments from one particular source of funds, to be sure, the most obvious source of funds, but they say those funds will not be available to make payments under the program. The Federal Circuit in the decision below said that was sufficient, essentially to mean that the government didn't have to make essentially any payments. The court accepted certiorari in these three cases to decide whether that's the correct answer. The last thing I'll say about this is obviously an important case just because of the amount in controversy. It's an important case because it's another opportunity for the court to wrestle with the Affordable Care Act, but to do so in a context where it's kind of not all or nothing. It's not an existential case about the Affordable Care Act. And so I think that'll provide some interesting sort of insights to how the court actually processes maybe a more normal case under the statute. But the other thing that's important about this case, and I think one of the reasons I wanted to highlight it today, is there's some questions in the law that you'd think would be settled 225 years into our constitutional experiment. You'd think we'd already know the answer to what happens when Congress says, hey, yeah, we'll make some payments, but they're not due for 5 years. And then Congress 5 years later says, yeah, that's interesting, but we're not going to appropriate the funds. You just think there was like a crystal clear answer to that question that was provided, I don't know, because of something Andrew Jackson did or something. And instead, it's really, a debatable question. I think, I'd like to think that the challengers had the better side of the argument, but the government has some cases on their side as well. So it'll be very interesting to see the court wrestle with that question.
And I want to, before we turn away from the ACA case, I want to invite other panelists in to give their thoughts on it, including a question I have is we frequently see the court in situations like this say, well, this is a question that's up to Congress. Congress can act. Of course, Congress usually doesn't act. But is that a potential outcome here? What do you expect to come out of this case? Anyone?
Don? Yeah, okay, good. So, I think that, I suppose, in theory, Congress could appropriate the money now to make good on the prior promise. That doesn't seem like a likely outcome. And therefore, it seems like the court is going to have to wrestle with exactly the question that Paul posed in the way that he posed it. But I do think it points up one of these really interesting things that happens. It's happened with a bunch of the ACA cases, is that normally a big law like that gets enacted, and you start implementing it, and you realize, well, we need to tinker with this, and we need to fix that, and try to make the law work. But once you had a change in parties in the House of Representatives, that just wasn't going to happen, and so a whole host of issues ended up in court, and that was true for years, and continues to be true with the case that Paul now has.
Okay, and one point that I forgot to make at the top, housekeeping point. One, we will have questions at the end, so if you have a question, keep in mind there'll be some time later on. We'll have folks with microphones coming around to allow you to ask that question. And to all of our panelists, if you have an issue paper, a brief in a case, any other area of expertise, as Paul did, please state that at the beginning. I think we will move on now to immigration and the DACA case that is before the court this year, and we will turn to Shoba for that.
Thank you so much. I'm really honored to be here, and as you might have gleaned from the introduction, I come to this issue as an immigration lawyer, scholar, and teacher, and I am going to focus on the choice by the administration to end a policy known as DACA, or Deferred Action for Childhood Arrivals. I suppose my disclaimer is that I've been an expert witness in some of the rescission challenges, and also been co-counsel in amicus briefs filed on behalf of immigration law scholars. We will be filing a similar brief in anticipation for oral arguments, which will be held on November 12th of this year. And the U.S. Supreme Court has consolidated 3 cases. In all 3 cases, the challenges argued that ending DACA was a violation of administrative law. So that was sort of the undercurrent in all 3 of the judicial outcomes. So no conflict as of yet. DACA was announced from the Rose Garden by former President Barack Obama on June 15th, 2012. It allows people who came to the United States before the age of 16, who are in school or graduated and meet other requirements, to apply for deferred action. Deferred action is one type of prosecutorial discretion in immigration law, and the legal foundation for it is crystal clear. And the legal authorities and the use of deferred action in the immigration system spans decades. To provide some of the legal authorities, the immigration statute, federal court decisions, legal opinions by Republican and Democratic legal counsel in both the former Immigration and Naturalization Service and the current Department of Homeland Security have all affirmed the legal authority for DACA. And it has been a true success, enabled over 800,000 people to have deferred action, work in a range of industries. I've witnessed firsthand on a sprawling college campus the benefits of DACA-mentored recipients in our classrooms and in our educational institutions. And despite this success story and the strong legal foundation for DACA, on September 5th, 2017, through a press release, former Attorney General Jeff Sessions announced that DACA would end. He called DACA-mentored recipients illegal aliens, and he called the policy an unconstitutional exercise of authority by the executive branch. I conducted several interviews with DACA recipients in connection with a new book called Banned, and one of the individuals I interviewed took her lunch break to listen to this press conference and found it to be a dehumanizing and defeating moment. The fate of DACA at the Supreme Court is uncertain, and it may hinge on whether the court believes the case is reviewable at all, and if yes, the legality of how DACA ended. So if the case is reviewable, the government proposes 3 arguments for the legality of how DACA ended. First, it believes that the judicial outcome of a deferred action policy for parents, known as DAPA, provides a basis for finding DACA as unlawful. Second, it argues that DACA creates an incentive for non-citizens to migrate to the United States southern border. And the third argument is that they believe that DHS was correct in concluding that DACA is not just legally questionable, but indeed unlawful. So these These arguments raise several concerns, all of which I believe are deeply flawed. First, the litigation in DAPA, argued so eloquently by the SG to my right, has nothing to do with DACA. Whether the never operational program of DAPA was a lawful exercise of prosecutorial discretion is simply unrelated to the case here. And just as a background, DAPA was a policy that would have enabled qualifying parents to apply for deferred action. Texas and other states challenged the program as unlawful, and the case went to the U.S. Supreme Court, deadlocked in a one-sentence order, meaning that the lower court ruling made it that DAPA was never implemented. And to my left, stating so eloquently, the former SG Walter Dellinger shared the outcome powerfully when he said, "Seldom have so many hopes been crushed by so few words." Moving to the government's second argument or attempt to connect immigrants arriving at the southern border policy to the DACA policy, that's just faulty. People arriving at the southern border are doing so in large part because of their dangerous conditions back home. I represent these clients. They are not here because they heard about a DACA program, which, by the way, by its terms, only applies to people who have been in the United States for over 10 years and meets other requirements. Finally, I believe the government provides a flawed analysis for why DACA is unlawful, concluding without explanation that none of the statutory authorities that have long been interpreted to make prosecutory invalid apply. Really, regardless of how the U.S. Supreme Court rules in this case as a matter of law, the choice by the Trump administration to end DACA represents an extraordinary use of discretion. So we could even pivot to the use of discretion from one administration to the next. It is morally troubling and out of sync with our history and our humanity. I look forward to your questions.
I would love other people, including the SGs that you referenced and everyone else on the panel, to give their thoughts on it. I have one question I have is, in your opinion, the fact that we have heard the president weigh in on this and say that he would be willing to act or work with Congress to come to some sort of solution, but he wants to wait first to see what the Supreme Court will do. What, if any, impact do you think that might have on the justices when they're deciding this?
You know, the flip-flopping we've seen by this president around Dreamers and a solution really provide nothing more than ambiguity in my mind. And, you know, I've always believed that it's never been an either-or debate about whether to sustain DACA and also support a long-term solution through something like the DREAM Act. So it's a false premise that in order to have legislation, we need to end DACA. You know, how the judges are going to make a decision regarding legislation, I hope they don't connect the two to some degree, because whether there is legislation on the table really is a separate conversation and question to the case here, and that is how DACA ended and whether it was lawful.
I'm sure anyone else have some thoughts on the DACA case?
You know, only that I guess there are different ways of losing the case, and they have different consequences. The court could hold that, assuming without necessarily saying so, that President Obama was within his authority when he used the discretion conferred upon the secretary to set immigration priorities in doing the deferred action, and that President Trump was similarly within his statutory authority and reversing it. That would leave the way free for a future president to use the existing statutory language to return to the position taken by President Obama, just as we've gone back and forth on issues like the gag rule, in the reproductive rights context, depending on the president. You know, the other way to lose the case that that Trump was right to rescind the order because the Obama order was itself unlawful, is more damaging. It would mean that no future president without additional legislation could return to that. One reason a court might be hesitant to go there, and one reason that the government may have been somewhat hesitant in pushing that argument, is that it may require some reasoning which would constrain future presidents of either party in terms of the degree of discretion they have under statute. So the court might wish to avoid going down that road, or they might wish to.
All right, so up next, we're going to talk about the Title VII cases involving sexual orientation and gender identity bias claims. And for that, we'll turn to Katie.
Thank you. So I, too, should disclose my priors. My very first job out of law school was as a public interest fellow bringing employment rights claims on behalf of LGBT employees. So I've been thinking about these issues for a long time on a particular side of the issues. I also co-authored an amicus brief on behalf of the employees in the various cases up before the court. So as I'm sure for most of these cases, it turns out to be incredibly difficult to encapsulate the arguments in 5 minutes. In particular, in these cases, there are 3 different cases. The parties do not all argue the issues in the same way. So I'm going to do my best just to give you a flavor of the principal argument in the cases. And then hopefully we'll have more chance to get into the nuance in the discussion and the Q&A. So first, what is at stake in these cases? So what is at stake in these cases is whether or not LGBT employees will be found to have protections against workplace discrimination under federal law. So as no doubt all of you know, there is still no federal law that explicitly includes sexual orientation and gender identity as discrete protected classes for the purposes of employment. But Title VII, our core federal employment discrimination law, does prohibit discrimination, quote unquote, because of sex. So that's the focus of the arguments up before the court this term. The plaintiffs contend that anti-LGBT discrimination is necessarily also because of sex. And of course, the defendants and the United States are arguing to the contrary. So I'm going to dive in just a moment to the affirmative argument for the plaintiffs. But before I do, I wanted to dispel the notion that this case is about the issue of whether sex means sexual orientation or gender identity. So this is an argument that the defendants spend quite a bit of time sort of rebutting. Sex doesn't mean sexual orientation. Sex doesn't mean gender identity. It's one I often hear raised by those who feel the case should come out against the LGBT employees here. But to be clear, that's not the nature of the arguments that are being made in these cases. So all of the plaintiffs, except for the purposes of argument, the narrow understanding of sex as quote-unquote biological or birth sex, so the sort of narrow definition of sex that the defendants have argued for. But even taking this very narrow understanding of sex as your starting point, there's an excellent textualist argument to be made that anti-LGBT discrimination is indeed necessarily because of sex. So although often textualist arguments are sort of thought of as benefiting conservative causes, in these cases it is quite the reverse. So unpacking a little bit the nature of the textualist argument here, the core provision of Title VII provides it shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of such individual's sex. So the key phrase here really is because of such individual's sex. And dating back to the 1970s, the Supreme Court has recognized that the causal language here, because of, connotes in its plain meaning but for causation. So what that means is if an individual would have had a different outcome but for their sex, this is because of sex within the meaning of the law. And key to understanding the arguments of the LGBT plaintiffs in these cases is understanding that in each and every individual instance of sexual orientation and gender identity discrimination, it is because of sex in precisely this sense. So it would not have happened but for the quote-unquote biological sex of the employee. So to give an example, if a male employee, Mark, starts dating a man, David, and his employer fires him as a result, The employer has, of course, engaged in sexual orientation discrimination, but the outcome would also be different but for Mark's sex. So if Mark were instead Sarah, a female employee, and did the exact same thing, went on a date with David, she would not have been fired as a result. So too, if Maria, a transgender woman who was assigned the male sex at birth and is identified by her employer as a man, shows up to work in a skirt or a dress and she's fired as a result, the employer has engaged in gender identity discrimination, but it has also acted because of sex, right? If the employer identified her as a woman, it would not have objected to the conduct that resulted in her termination, i.e. Wearing a skirt or a dress. So again, the principle here is really quite straightforward. And to me, many of the various permutations of arguments that are being made in these cases really collapse back into this basic textualist principle. So under Title VII, if your protected class determines the outcome, that is because of sex and thus unlawful. And that is precisely what happens in each and every case of sexual orientation and gender identity discrimination. The last thing I'll say before opening it up is that I am probably more optimistic than most progressives about the possible outcome of these cases. I certainly don't think it's assured that the LGBT employees will win, but I do think that the textualist argument is a very strong one and one that those with principled commitments to textualism ought to be taking seriously. Laughter. Many legal realists in the room.
So I'm going to throw out a question for Katie and anybody else who wants to jump in on this or make any other point about this case. The last time we had a big LGBTQ case before the court was the Obergefell case. And in that, it turned on issues, well, Justice Kennedy spent a lot of time talking about the change in, or even during the arguments, the change in public sentiment toward the LGBTQ community. And Justice Kennedy wrote a lot about things like personal dignity. How much, if at all, do you think those types of principles will play as the court considers these cases?
So I think that those types of principles have relatively little role in these cases, except by way of explaining why the lower courts got this wrong for so long. So Jessica Clark is a legal scholar at Vanderbilt, has out a great article about this. Right? You might ask the question, if Title VII meant this all along, why did the lower courts get this wrong? Right? Because early lower courts said no, gay and transgender employees are not going to be protected here. And I think the obvious thing that explains that, right, is the extent of biases against LGBT people in the United States at the time those cases were decided. I also think that the shift towards textualist methodologies in statutory interpretation has also played a significant role in shifting the landscape on this.
And what opportunities here do you think there might be? This is a court that likes to rule narrowly, likes to, you have folks from, whether it's the Chief Justice or justices like Elena Kagan who like to have consensus where possible. Is there a place to be met in the middle without making a broad ruling, or is this an all or nothing type of case?
It's hard for me to see a narrow way out of this, simply by virtue of how these cases came up. There have been in the lower courts arguments that were framed in narrower ways in earlier cases, but they specifically took cases where this was framed as the key issue of whether, sort of all or nothing, is LGBT status covered or not under because of sex.
Yeah, I mean, the one thing I would say about it is that the change in cultural attitudes and norms in society, I think if it has an effect, a likely effect it's going to have may be an opinion, the tone of which is more along the lines of, yes, this is a significant problem, but it's not one that Congress has yet addressed, and it's Congress's job to address it, not ours. I think, whereas a quarter century ago, I don't know that you'd have an opinion like that, but I think to the extent it is an effect, I would expect it to be something along those lines.
Can I just ask one question, which is, do you think the sort of two cases, three cases, but the two different issues stand or fall together?
That's a great question. I think that the core central textualist argument is, runs across both cases. I think there are the lower courts sooner recognize the logic of why anti-transgender discrimination is sex discrimination. Under cases like Price Waterhouse, it's hard to articulate a theory as to why Ann Hopkins can be gender nonconforming, but Amy Stevens cannot. There is, I think, some possibility that you see a win on the gender identity side of the case, but sexual orientation is sort of a step too far, even though, again, I think the core argument is essentially the same. The other sort of wild card here is that the case involving a transgender employee also involved a sex-specific dress code that wasn't challenged. So there's this really odd fact that the defendant is actually leaning very hard on to say this was specifically about failure to comply with the dress code, and sex-specific dress codes are legal. So I think that could complicate matters as well.
All right, another big case that the court is taking up is pitting or causing some tension between the Establishment Clause and the Free Exercise Clause. It's the Espinoza case that Walter's going to take us through.
This is one of those cases that makes me very much wish that Sandra O'Connor were still on the court. When I was clerking for Justice Black, he would often, at that point in his career, write down follow White in a particular area of the law, or follow Harlan in another area. And what I put down in cases like this in my mind is follow O'Connor, because I thought she got all of the cases right for the whole Rehnquist era. And she was actually in the majority, I think, almost all the time. And in decisions that were 5-4, she would vote with the what we think of as the more conservative justices to uphold the permissibility of including religious groups in general broad-based public programs, so that she was the fifth vote, and sometimes there were only 5, to my amazement, that held that if the Communist Boys Club could meet after school, then a Christian group could meet after school as well, to hold that when you provide an interpreter for a deaf child, she can use that in any school, parochial, sectarian, or private, that if you do vocational training, and you can go to divinity school with the open vocational training for the blind, you can go to divinity school with it. And I was comfortable with all of those. In fact, divinity school, being a minister can be, a very good living these days. And from what I see, living near Tammy Faye Baker, if you remember her. And so I thought that, O'Connor had a very simple but powerful insight. Her position was private prayer good, government prayer bad, so that she would be receptive to upholding the right of religious groups to participate in public funded programs, but not for the government to be making the religious decision itself, by having prayers at council meetings, by putting up statutes to the 10 Commandments. She was, in almost all of these cases, someone that thought that government had no business sponsoring prayers and making the decision. I think she had an instinct that the key in all these cases was intervening private choice. Intervening private choice was sort of the circuit breaker. And so what was wrong, I think, with the graduation prayer in Lee versus Weissman, and a similar prayer in the Texas football case, where I think Paul and I were on different sides, but almost very close in our analysis until the last stage. In those cases, the government is saying there will be prayer. And the minister is allowed to have the podium at graduation if, but only if, the minister will deliver a prayer. And the same is true of Town of Greece, etc. So I thought in all of those cases it was wrong, but if you had intervening private choice as a circuit breaker, as you did when a student decided, I want to do a Christian club, or someone who is being provided with an interpreter for the deaf said, I want to go to a parochial school, that's the circuit breaker. I felt a little, betrayed is too strong a word, disappointed when my conservative friends didn't follow through on that. I thought in the contraceptive cases, where there is a circuit breaker, I think we should have said to the families that own the company, It's the employee who makes her decision about what she wants to do and with her religious or moral beliefs about the use of contraceptives, and you don't get to tell her, what to do. I know they're not the government, but it seemed that the circuit breaker principle was there. So the Montana case is one of these where I think if you get to the complexity facts, and I think the facts are complicated because the Montana legislature was trying to work their way around what they saw as Establishment Clause problems by providing a tax credit for families to give contributions to essentially foundations that provide funds for schools for children who get to choose what they do with the funds, but they give them to children who are already in parochial schools, I would assume, from the facts of the record, but a convoluted way for money to get into the hands of religious schools. We all have different policy views about that. I'm a strong public school adherent, but I think on the merits that a true voucher program that's not gerrymandered to favor religion or one religion is okay. A GI Bill of Rights to go to Notre Dame or even Divinity School struck me as that, and I wish O'Connor were there to be in the majority in all of the cases, sometimes with the progressives and sometimes with the conservatives. Very interesting issue in this case. Paul, are you involved in? Because I want to ask you.
Amicus brief on behalf of the challengers.
Yeah, because the most interesting thing about the case is, so the legislature passes this program. Some of the money gets to the, and by the way, when people quote Jefferson saying not 1 pence for religion, that was in a day when legislatures didn't appropriate money for general social programs. When they were going to have a bill to provide funding for the Episcopalian ministers, not we're going to have a large social program and we're going to let religious adherents participate in it. So that's sort of where my view is. But the legislature adopts this program. The state Supreme Court holds it unconstitutional under a constitutional amendment that prohibits funding in aid of religion in that state. And then it is, but the Supreme Court, in holding that you could not have these funds available for religious institutions, a position that the Supreme Court will probably think is incorrect, then went ahead and canceled the whole program as a matter of state law. And so one argument is not that the claimants lack standing. They would still like to have, they're requesting funding or tax credits, but nobody gets tax credits anymore. So there's no discrimination. This is like Palmer against Thompson, when the city was ordered to integrate its swimming pools in Jacksonville and closed all the city pools, like everybody out of the pool, and the Supreme Court said, well, they can do that. They can decide not to have swimming pools. And the end result here is that Montana doesn't have such a program anymore. And most revealing, Garrett Epps, who's got a very sharp eye out for these things, and is here today, Garrett pointed out to me a great concurring opinion by, an interesting concurring opinion by Judge Kavanaugh, in the case where you could have everybody could have a spiritual advisor behind the glass at their execution. But only certain religions could have a spiritual advisor in the room, and not including a Buddhist death row inmate. And Judge Kavanaugh said this is one of those cases where the state can cure the problem either way. They can simply not have anybody have a minister with them, when they're at their execution, and that would solve the problem. It seemed to me I couldn't see any distinction. Paul will have one because he always does. I couldn't see any distinction, so I thought that given Kavanaugh's position in cases like Palmer against Thompson and Texas Monthly, where states are said you can cure an equal protection problem by going up or by going down, I'm not sure how Montana ended up leaves the petitioners with a problem. Paul,
I do have an answer to that. It's all pretty in the weeds. I think what to me is different from the Palmer situation or other hypotheticals is, if the Montana legislature had passed this law which provided the money to be available based on independent choices to either private sectarian schools or private non-sectarian schools. And then the court had sort of struck part of it down, and then the legislature had decided, this is a mess, let's just cancel the whole program. Then I think there would be a bigger problem for the challengers and sort of the state of the case. But this was all sort of a remedial choice of the Montana Supreme Court based on the fact that they found that the statute the legislature passed was in fact unconstitutional under the state constitution. And what they basically held is you can't let the money go to the religious schools, and the way the statute's set up, some combination of the legislature's intent and the lack of any safeguards means you can't have the whole program at all. So to me, that still means that they struck down the program based on their state constitutional provision that doesn't allow the aid to go to religion. And so maybe at the end of the day, like, the Montana Supreme Court decision doesn't look as discriminatory, but it's still, at the end of the day, the parents lost an ability they would otherwise have to send their child to the school of their choice because of the state court's application of the no aid clause in the Constitution. So I tend to think the issue is still squarely teed up. I mean, for what it's worth, Montana did a pretty good job. You can always do a better job, but did a pretty good job of kind of pointing all of this out in its brief in opposition, and the court took the case anyways. Right. So, I think, although I would anticipate Montana's going to make another shot at making this argument, that the court, a majority of the court, at least 4, will be unimpressed by it. The only other thing I would say about this case is I think this case is a very interesting example of kind of the path dependency of Supreme Court cases and when cases kind of get there. Because, you were saying you've been involved in some issues since the beginning of your career. One of the very first cases I was involved in was Wisconsin school choice. And the original version of the Wisconsin school choice program was limited to non-sectarian schools. So when they had the original pilot program, you could only use it at non-sectarian private schools, of which there were only 2 or 3 in Milwaukee, so it was a very limited program. There was a challenge to it on free exercise clause grounds. It said that's discriminatory. There it is, right in the statute, non-sectarian. That's discriminatory, free exercise problem. Kind of got the back of the hand by a district court judge and didn't go any further. And then they eventually expanded the program, and then kind of But what makes so a claim that was sort of viewed as not very promising 20 years ago now seems like it may have a majority of the court willing to accept it. A part of it is, to be sure, the change in personnel, and Justice O'Connor's not there. But part of it, I think, is in the school voucher cases and other cases in that line, the court really stressed this principle of there's intervening choices by the parents that creates a circuit breaker, and it kind of makes the government's interest in whether the money goes to a private school that's religious pretty attenuated. And so having held as a matter of federal constitutional law that the state's interest is pretty attenuated, you then have a case like this where there's nothing particularly attenuated about the effect on the parent. The parent wants to send their child to a school that they think is going to provide a better educational opportunity for this child than the public schools. They've decided that the right school for their kid, based on sometimes wholly non-religious reasons, sometimes religious reasons, is this particular religious school, and they're being told, no, you can't do that, that's unconstitutional. So I do think the real challenge I see for the state in this case is, the state's interest seems pretty attenuated, and the parent's interest seems pretty direct.
Is this a case going where I would not go, though I would go with you part of the way, but not to where there's some hints in the SG's brief that you could apply this to parents that say you have to fund religious schools if you fund a system of public schools, even if you don't fund private non-sectarian schools? Yeah,
I think that probably goes too far. And I'm not, there may be some lines in there that have that flavor, but I at the end of the day, I don't think deciding this case in favor of the challengers would sort of necessarily carry that consequence. The one thing, the one other plea I'll make, to sort of the group here is, I think long and hard about cheering for the challengers on this one, because this is a constitutional civil right that a working majority of this court seems to be enthusiastic about. And I think, if they have, some of these principles, the very fact that you're saying, well, this might be in some tension with Palmer, if they decide this case in favor of the challengers, it's going to carry over, I think, for the logic of some other civil rights. And even if the free exercise clause isn't on the top of your list, the way it is with maybe some conservatives, you may want to take advantage of the fact that this is a genuine, non-discriminatory civil right that a majority of this court seems to be pretty excited about.
Yeah. No, I don't think any progressive should be in favor of furthering Palmer. It has lots of implications for other areas which progressives might find more sympathetic.
Okay, there's still more cases. This is just telling you what's on the docket, including the Second Amendment. It's a case about a ban on transporting guns outside of New York city limits, and we are going to sort of do a tandem team here on this one and ask Paul and Don to talk about this case. Don, you can start.
Sure. It's Paul's case, but I'll start. This is a case coming out of New York City, and it involves a municipal regulation that required handgun licenses and said as a condition of those licenses, you were subjected to numerous restrictions. You could possess the handgun in your home, and you could transport it to and from recognized shooting ranges in New York City, but otherwise you couldn't transport the handgun anywhere. Was challenged as a violation of the Second Amendment. The Second Circuit upheld it. Supreme Court granted review, and was highly anticipated case because since the court in Heller recognized a fundamental right under the Second Amendment to bear arms, the lower courts have been struggling with exactly how to apply that to the myriad state and local firearm regulations that exist in the country. Does the recognition of this right as fundamental mean that that virtually all regulation is impermissible? In contrast, is there a wide scope for reasonable regulation of firearms? And should you analogize the Second Amendment to, say, the First Amendment and think about it in terms of tiers of scrutiny, strict scrutiny where the government has to have a compelling interest and it has to be the most narrowly tailored means available to justify regulation? Is it some form of intermediate scrutiny? Does it make sense to think about it in terms of scrutiny at all? Or should we instead think about it in terms of history? All these questions really bedeviling the lower courts. Supreme Court has taken the case to try to work its way through them and it took a regulation that was probably more restrictive in more ways than most state and local regulation of firearms. Cases on the Supreme Court's docket, and New York City and New York State then worked together to repeal it. And so it's now been repealed, and so in addition to, or as a prelude to the I think very interesting and significant Second Amendment questions that the case raised, there's a question of whether there's a case for the court to hear at all, and the argument by the city is, well, what law? There's no law anymore. Therefore, this is a moot case. There's nothing to challenge. And Paul can elaborate on this more. But the argument on the other side is, no, this is an exercise of something that the law recognizes as voluntary cessation of unlawful conduct, and that in that situation, you don't let a party avoid judicial review by engaging in voluntary cessation to deprive the court of the ability to rule on something that the court could rule on in a situation where it may well come back. So anyway, that's sort of my take on it. But Paul, why don't you feel free to elaborate?
Sure. No, I'm happy to. Look, maybe it's a bridge too far to say this is just another civil liberties case where you should be rooting for the challengers. But
Try it. That's good.
But that said, it is funny because that is sort of the structure of these cases. I mean, you do have individuals trying to vindicate a constitutional right against governments, and that's why on both the mootness issue and the merits, I think they're interesting aspects of this case, and that could have some implications for some other constitutional rights. I think that's most obvious on the mootness, because if you sort of abstract away from what the case is about, this idea that, a jurisdiction would pass a law that's restrictive of a particular constitutional right, it would do pretty well in the local courts. The Supreme Court would grant cert, seemingly spelling trouble for the local jurisdiction, and all of a sudden the law kind of disappears and kind of deprives the Supreme Court, of a chance to say kind of what the law is. And, that could be replicated in a lot of different contexts. It's a little bit like why we had Section 5 of the Voting Rights Act, frankly. So this, this issue of kind of voluntary cessation by governments, I don't think has a political valence, and I think there is something, in my view, a little bit troubling about the idea that that a local government would have sort of a complete sort of liberty to get rid of its law once the Supreme Court granted review, just given the nature of a court with discretionary review. I think if you think about just a typical court of appeals where they have mandatory jurisdiction, they take all the cases. If the government makes the law that arguably intrudes on some constitutional right go away, I think the obvious reaction for the judges would be, that's great, because I got like 30 other cases I got to hear, and let's just move right along. But when you have a court that spends a lot of time picking 75 cases out of 10,000, and then after they do that for particular reasons, then one of the parties makes a case go away, I can see a court with discretionary review wouldn't react to that the same way, and maybe shouldn't react to that the same way. But that's kind of the mootness issue that the court will be wrestling with. And then on the merits, just two other observations. One is, again, if you like other constitutional rights, you might want to worry a little bit about a version of intermediate scrutiny that means that the government always wins. And that's kind of the way that intermediate scrutiny in the Second Amendment has been applied in some circuit courts. And maybe that's a reason not to root for the challengers, but maybe to root for the court to analyze the Second Amendment in more sort of sui generis kind of tradition ways. But as somebody who litigates some Second Amendment cases, but some First Amendment cases as well, the idea that the government wins over 50% of the cases under intermediate scrutiny, that's not how I understood intermediate scrutiny. I grew up thinking, if I got out of rational basis as a challenger and into intermediate scrutiny, I was going to bat better than 500 in my cases as a challenger. So there is that kind of universal principle as well. Look, the other thing that's interesting about both the merits and the mootness question is the court, essentially took 10 years off after McDonald in Second Amendment cases, probably for some very obvious reasons. But, this case, because it's a relatively narrow case, it doesn't address some of the bigger issues that are out there, like right to carry. It wasn't a bad case for the court to pick to sort of dip its toe back in the waters of the Second Amendment and say something else about the case. And I don't know that there's another case out there. I mean, there are other cases waiting in the wings if the court dismisses this case as moot and doesn't reach the merits. But they're more, broader cases about the right to carry and the like. So I think, I don't know how that's all going to shake out in terms of the court's thinking. But, this is not a situation where there's an absolutely ready substitute waiting for the courts in the wings so that, if the court says, well, it's either moot or kind of moot, so maybe we'll pass on this one. I don't think there is a ready substitute. The issues that are waiting in the wings are actually bigger ticket issues, and the court may have reasons to not want to wrestle with those immediately.
Yeah, and they didn't. They could have dismissed the thing as moot already, and they haven't done that. And so that suggests that at a minimum, they're taking that set of questions very seriously.
We still have more cases to go through, but I would be remiss if I didn't let Walter weigh in if you have any thoughts on this case, since you did argue a little known case called Heller.
I actually think that the underlying issue of whether it would be an urban metropolitan area can prohibit the possession of handguns outside the home as long as they allow secure transportation between, if you have two homes, between the two homes. As someone said, the answer to have two guns isn't an answer. Nobody wants to leave a loaded gun in their place out in the country. It's not a good idea. So that was an original part of the New York law that I think was focused on in the cert petition. and the fact that you could only go to gun training, which is supposed to be responsible gun ownership, within the boroughs of New York, when the better, more convenient club might be across the bridge. I think that was just not a mistake, just a fact of the matter that the New York Police Department only certifies institutions in the city of New York. And if someone wanted to make a case that it was important to do it outside of New York, I think the answer should be, yeah, let them go outside of New York. We'll go to the trouble to certify it since there's a constitutional interest involved. When I argued Heller, it was very interesting meeting with the police chief, Kathy, and her top people. They really cared about possession of guns. Actually, they didn't see Heller as that much of a loss. That is, if the right was going to be limited the way the court saw it in that case, is whether you have the right to possess a handgun in your home. They're okay with that. It's possession of handguns out in the community, in subways and buses and schools and all the other places. And the fact that it was a very, very important law enforcement tool for them, because you arrest someone, people who are about to do bad things like to have a gun with them, and when you catch them with a gun, you've got them. They've committed a felony right there. Now, maybe it's from a civil liberties point of view, we might be concerned about how easy that makes it, but leave the gun at home. But they really think that guns out in the community and an ability to stop handguns out in the community is the real problem. And the Heller right of having a gun in your home, at least the police are more okay with that.
I'm going to make a hard turn just because I want to try to stay. We still have a lot to get through and we're running out of time, and keep you right there, Walter, to talk about the Puerto Rico cases that are on the docket involving the Financial Oversight Board and Promesca. I'm glad that someone other than me is excited about these cases, so I'm going to let you take it away.
Let me pitch that to Don, who actually represents the board whose constitutional validity is at issue. I represent the government of Puerto Rico, and we are a bit on the sidelines about this case involving our overseer.
All right.
Thank you, Walter. Yeah, actually, why don't you just say nothing else? So this case has much less political salience than the cases that we've been discussing so far. It's much more of a law nerd kind of a case. It is a case where I'm litigating, as Walter mentioned, on behalf of the Financial Oversight Board for Puerto Rico. Congress enacted a statute in 2016 called PROMESA. The point of it was to deal with the massive fiscal crisis in Puerto Rico. Puerto Rico was insolvent, had, I think at that time, about $80 billion in debt it couldn't pay. It was a catastrophe. It also wasn't eligible under existing law to try to reorganize its finances in bankruptcy in the way that, like, the city of Detroit could. So the statute basically did two things. It created a bankruptcy-like mechanism that borrows a lot from normal bankruptcy law and procedure to allow Puerto Rico to reorganize its debts, and it created a financial oversight board, which was modeled on the financial oversight board that Congress created for the District of Columbia back in the 90s, and gave it some power, not unbridled power, but some power to impose fiscal discipline on Puerto Rico, the power to approve budgets and engage in other kinds of activities to try to restore some fiscal discipline, with the goal of getting Puerto Rico's finances back to a place where they could go back into the financial markets and raise money through bonds to fund their operations. The board was constituted, it started doing its work. And first a couple of hedge funds and then a union brought a constitutional challenge to the board. And it was based on the Appointments Clause of the Constitution. The Appointments Clause requires that officers of the United States be appointed in a certain way. If they're principal officers, that they have to be appointed by the president with confirmation by the Senate. If they're inferior officers, they can be appointed by the president alone, or the heads of departments, or the courts. That's the language of the Appointments Clause. And the statute PROMESA provided two ways in which these board members could be appointed. They could be appointed in the one of the Appointments Clause ways. They could be nominated by the president, confirmed by the Senate, or instead they could be picked by the president from lists that were provided by the majority and minority leaders of the Senate and the House, in which case they didn't need to go through confirmation. So a couple of hedge funds that were not really happy about the way in which the financial, or who had bought a bunch of Puerto Rico bonds, weren't really happy about the way the financial arrangements were being made and how much they were going to get back on those bonds, brought a constitutional challenge saying, look, these members of the board are officers of the United States. They were picked by that list mechanism. That doesn't comply with the Appointments Clause. Therefore, they lack authority, and everything that's happening here is ultra-virus. And what the case comes down to is whether they are officers of the territorial government or officers of the government of the United States, and A, whether that matters in terms of the Appointments Clause, and B, if so, how do you determine which of those categories you put them in? And for me, it's an incredibly interesting case because it's like two cases that I was lucky enough to do when I was SG, Noel Canning, the recess appointments case, and Zivotofsky, the case about the Jerusalem passport statute, and that we've been living under our Constitution for 200 and some odd years now, and the Supreme Court has never considered this question before. And in fact, no lower court has ever considered this question before until this case. And so much of what you've got to do is kind of go back through the history and think about first principles and argue on the basis of first principles and how they have played out throughout American history, as opposed to relying on a great body of precedent in the way we do in so many of these cases. And so that's what a lot of the fight is about in the case, is that you go back and the hedge funds bringing the challenge say, well, every single territorial governor from the time of the Northwest Ordinance until 1947 was nominated by the president and confirmed by the Senate. And we come back and say, yeah, but Congress provided for territorial legislatures to govern the territories, and those people obviously aren't appointed in conformity with the Appointments Clause, and then they come back with them, and we come back. So it's been it's a really, really interesting case from a separation of powers perspective and an American history perspective, and one with, I think, enormous practical consequences for the people of Puerto Rico and the ability of the government to get back on its feet. And then there's also a remedial issue in the case, which is, in the exceedingly unlikely event that we don't prevail in the case, what happens? Does the court have authority, do courts have authority to rule that the appointments are unconstitutional but not invalidate all of the prior actions of the board because of the disruptive consequences of doing so? So that issue is also before the court, and that's actually there have been a lot of amicus briefs filed in the case. The overwhelming majority of them have been on that second issue, and the reason, I think, is because of the CFPB and thoughts about if there is a successful constitutional challenge to the actions of the CFPB, what's the remedy? And so that's the remedial issue has actually drawn a very great deal of attention.
One brief comment, Kim, which is that in our reply brief, we filed a brief that was somewhat more political. The position of the government of Puerto Rico is that we're sort of in this position because Congress has failed to abide by what I would call a constitutional norm. And that norm is that there are a lot of things that the framers left unstated. That norm is that we would have territories of the United States, and the expectation would be that when they reached a certain level of population and civil society, that they would be admitted as statehood. And that's what happened recurringly until we got to brown states, and Hawaii never would have been in, except they had to make a deal with Alaska. And so what's wrong here is that, they didn't say the Constitution that when you have more than 25,000 people and it's been more than 25 years, you must be admitted as a state, but it was sort of understood that that's the way it was going to work. And now we've gone, centuries past the point at which Puerto Rico had the requisites that should have made them a state and made, none of these issues be any different than they would with regard to state and municipal indebtedness.
I want to get to audience questions in just a couple of minutes, and I just want to remind everybody a couple things. Please state a question and not a comment, and state it very, very briefly, and wait until you have the microphone from one of the folks here on the floor with the microphone before you start speaking. But as we ready that, I want to open up with one last question to the whole panel. A lot of the cases that we talked about today involve some form of check on executive authority. It comes out of some action or rule or rescission of a rule from the executive. We're also at a time where other issues about the executive, such as the subpoena power and other things, are likely heading to the court. Given that, what do you expect from this court as it takes on those issues about this administration in particular? We have a president who, quite frankly, talks about the Supreme Court as if it's a tool that he can summon to be used on his side. Does that have an effect? What do you think about these executive power questions that are either at or on their way to the court? Don, I'm gonna throw it to you.
Yeah, go
I mean,
Go ahead.
I'll
Shoba.
get started.
Okay.
So, I've already spent time talking about how I believe DACA is a lawful exercise of prosecutorial discretion, and it's an inherent and an explicit authority. I will talk about a case that I didn't get a chance to reach on immigration, coined as Asylum Ban 2.0. It really helps tell the tale of how the president is trying to summon the Supreme Court to work for the administration. Sometimes I wonder if the Supreme Court might be hired as an employee of the administration. So Asylum Ban 2.0 is an interim final rule that was issued in July of this year that blocks asylum for people who transit through an other country and arrive in the United States and don't apply for asylum in that country. And this was challenged in a federal district court in California. There was some ping pong between the district court and Ninth Circuit Court of Appeals, but ultimately, Judge Tegar issued a nationwide injunction stopping Asylum Ban 2.0 from going forward. Disclaimer, I'm co-counsel on related amicus briefs, arguing that it is a violation of the statute that Congress wrote to block asylum for people who enter the United States and transit through a country as a necessary consequence of their arrival. Lo and behold, in August, the Trump administration jumps to the U.S. Supreme Court and asks it to stay Judge Tegar's nationwide injunction before any kind of decision or discourse has been made in the lower courts or the appellate courts. We don't have a decision yet. And on September 11th, 2019, the U.S. Supreme Court put a stay on that nationwide injunction, making Asylum Ban 2.0 fully operational. And I guess I want to highlight one intellectual point and then one human point. The intellectual point is, when does a president get to speed race to the Supreme Court before decisions are made by the lower courts and have the highest court of the land say, that's okay, we're going to give you a free pass. We're going to have you go through the courts in a way that none of us learned about process in law school. We've seen this before. We saw this recently with the travel ban case. That is also a ban that was fully operational on December 4th, 2017, long before a decision was made by the appellate courts or the U.S. Supreme Court in June 2018. And my human point is that this rule that is now fully operational has a huge impact on people who are seeking asylum and coming through the southern border. Any Venezuelan, Guatemalan, Honduran, El Salvadoran is likely going to pass through Mexico before arriving in the United States. So I consider this to be one large tool in a broader plan by this administration to shut down asylum at the southern border.
All right, I wish we had another half hour to talk a lot more about this, but I do want to get to questions in the audience if people have a question. Right here, I saw your hand go up first. Wait for the microphone, please.
Thank you. Yes, so we didn't talk about abortion yet, but there are a number of cases potentially on deck. I'd love to hear each of your thoughts on whether the court in the next couple of years will reverse Roe v. Wade.
And for the record, I knew one of you would ask it, so I knew I didn't have to. Go ahead.
Well, I'm involved in the Mississippi and Louisiana cases on behalf of the clinics in those cases and the patients. The very stark challenge to this court, because the Louisiana case is almost an exact replica of the statute at Whole Women's Health, where, one of the first times the court has actually struck down a restriction in a very long time with Justice Kennedy's vote. And in part that was because we had not just the OBGYNs on our side, but the American Medical Association, which tends to be somewhat conservative and standoffish. But they came in and said, this is not, as the state does not simply fail to make out a case that it's important for women's health to have attending physician with hospital privileges. It's harmful to women's health. This statute is going to be really harmful to women's health. And when you have the AMA do such a powerful brief, I think that may have shaken some of the justices, a bit. But in any event, so the pro-choice groups prevail 5-4, and now bam, the issue is they just passed a similar statute, cut and paste, in Louisiana, is coming, and the Court of Appeals upheld it, notwithstanding Whole Women's Health. And so to reverse it so soon would be shocking. I don't think you will ever hear the words Roe versus Wade is hereby overruled stated. It would be, I hate to be cynical, but it would be too much of a political boost to pro-choice groups to have those words uttered when all the court has to do is to make provider availability so difficult that you have effectively ruled it out, at least for women who are hostage to youth, poverty, geography. Those who are challenged will, effectively have no access to the ability to terminate pregnancies.
So I have a different view about that. This is not the first time I've said it, but there are two kinds of, broadly speaking, there are two kinds of laws out there that regulate and restrict abortion. One is laws of the nature that Walter described in the Louisiana, Mississippi cases, was issue in the Texas case, where the fight is about whether the state laws are imposing restrictions that constitute an undue burden. And there's a balancing test, that kind of analysis. Yeah, but there's another category of laws out there which I don't think you can think about really in undue burden terms. And those are the heartbeat bills and the bills that go even further than the heartbeat bills, like the Alabama law. And a number of states have enacted those laws now, and I think more will. And they don't pose the question of whether the state is imposing an undue burden on your choice about an abortion. They say after X date you may not have an abortion, and X date is well before the end of the period in which presumptively, subject to reasonable regulation, you can have an abortion under Roe against Wade. Now, it's possible that the lower courts will uniformly strike all of those laws down, and the Supreme Court will never take a case involving them. And I don't think it will happen the next year or two that they would. But if enough states enact those laws, my sense is that the court at some point is going to feel like it has an obligation to consider the constitutional question. If you have 10, 12, 15 states enacting laws like that, which is not out of the realm of possibility, then I think the court's going to feel an obligation to consider it. And when they do, my own sense of it is all bets are off at that point.
Right, had another question right here.
Hi, I have a question about the DACA case, and I wonder if folks in the panel have thoughts about why are we here in this posture, because presumably the administration could just say, actually we're doing it as a matter of discretion, a different policy, and change it, but instead they're sticking with the position that it's unlawful. Is it simply they don't want to say for political reasons that this is voluntary, or is it a legal strategy that they want a decision on this particular issue? And if it's the latter, is it unusual for the executive branch to be arguing in favor of constraints on its own discretion?
So, my own sense of it is that the one real hope that the challenges of the DACA rescission have is if a majority of the justices feel like the political accountability has been shifted to them instead of being assumed by the executive. Because it can sort of, and that is one advantage that the unlawfulness argument has, is they're saying, well, we're not exercising our own policy judgment about whether this is a good or a bad idea. We're just following the law. And that's a less unpalatable position given the amount of sympathy that exists for the DACA folks in the country, and it could, seems some chance it could create some unhappiness on the part of the justices. I'm not predicting that's what's going to happen, but it seems to me that that dynamic is part of the case. It is, I suppose, it's possible that they want clarity. Pure legal clarity, and then that's why they have done what they've done all along. But, they were in a situation when Judge Bates in the D.C. case in particular, he basically begged them. He just said, just go, here, 60 days, 90 days, whatever it was, just go back and say you're rescinding it as a matter of policy, and I'm telling you, you will win. And the government didn't do that. Maybe they were confident enough in their judgment that they could get 5 votes for the proposition that it's just flat out unlawful and they didn't need to do it. But it seems it's based on that, it's deliberate. Whatever else you say about it, it's deliberate.
All right, we had a question right over there.
I wonder if any panelists have thoughts about the Comcast case, about whether a Section 1981 claim can survive in the absence of but-for causation.
I have some thoughts. For those of you who aren't familiar with this case, it raises the question of whether or not a motivating factor analysis is going to be applied under Section 1981, which is the statute that prohibits race discrimination in, among other things, contracting. And the sort of backdrop is that the court has said as to statutes like the ADEA and Title VII's retaliation provision that simply use language like because of, that connotes but-for causation rather than this lesser causal standard. I think that there are good arguments for why Section 1981 is different, right? The language is different. There's another statute, the federal sector ADEA, age discrimination claims are also up before the court on a similar argument. That statute, too, has different language, as to which I think it's easier to make the argument that really race, and in the other case, age, can't play any role at all. And in the Section 1981 case in particular, the Supreme Court has tied Section 1981 to equal protection jurisprudence in a way that provides another argument, which is that under equal protection, motivating factor is also enough. That being said, there's a block of the court that has shown itself to be very gung-ho about but-for causation as the standard under anti-discrimination laws. I actually think one of the bigger questions in these cases is not the issue presented, but rather will the court provide some clarity on what but-for cause means, and that but-for does not mean sole causation, because that's really the standard that scares anti-discrimination practitioners, and there's been some sloppy language, especially in the lower courts.
All right, I have time for just one more really, really quick question right here. Wait for the microphone.
Yes, I'd like to talk a little bit about federalism. There's a couple of matters percolating in California involving corporate average fuel economy and California's waiver given by the EPA to administer its own pollution laws. I'm wondering if any of you have any thoughts on those matters.
I mean, I can jump in because I'm involved in some of the at least the preliminary litigation involving it. I mean, I think those are complicated issues, and I think they will be litigated, very soon in the D.C. Circuit. The only thing I would say is, that's the statute that gives California kind of this primacy in coming up with almost like an alternative fuel standard for the federal standard is a pretty sui generis kind of situation. It's actually kind of fascinating from a sort of federalism standpoint, because you basically have a federal law that's basically saying, well, we kind of like a uniform federal standard, but we'd kind of like another one, and we're going to let California set the other one. I mean, and I don't think there's going to be any fundamental challenge to that arrangement, but it's just a very odd arrangement. So I think it's a fascinating case with the stakes are enormous. It's very interesting administrative law issues, but I'm not sure that it'll tell us too much about kind of blue state federalism and other issues that I think we'll probably have to wait for some other cases to get their way to the court.
The 22nd federalism course is that this court is much more likely to uphold states' rights claims when they're brought by Alabama than they're brought by California or Oregon.
And on that note, I'm going to ask you to join me in thanking the panel. Thank you so much.